Good afternoon, everyone, or wherever it is in your part of the world. It's Claire here with Shergroup on the sofa, and I hope you're in a good place today. So with me is my guest, Julian Steed, who's joining me from Norfolk in England. I am a Norfolk girl, as many of you know, and so it's always lovely to have a guest from my home county on the sofa today. So before we get into talking to Julian about his life and work, I just wanted to say a shout out to our #1 fan, Ross Saunders, who's also in North Walsham today in Norfolk. So, hey, Rossi, how are you today? I hope you're in a good place. And Julian wants to say hello. So
Hi, Ross.
He's giving you a shout out there as well. So, all right. Now, I know your firm. You're with Mills and Reeves in Norwich. And when I was a youngster, I went to City College and did a legal secretarial course. And Mills and Reeves was a place where everybody wanted to work. I just want you to know, you probably didn't even realise that, but that was a young secretary's dream to work for a partner in Mills and Reeve. Just there at off Prince of Wales Road. I guess the firm has moved on a lot since then. You can tell me all about that. But how about you? Are you a Norfolk? Are you a Norfolk guy, or where do you hail from?
No. I can't claim to be Norfolk born and bred, although my son and daughter are very much that way. No, I'm an immigrant from the outskirts of the West Midlands and came down to Norfolk in 1991. I had a job at Norwich Union for a bit in IT, which was what I did before I re-qualified. Did the crash course, law conversion course, postgraduate diploma, I think it's called now.
Yeah.
And then the Law Society finals, and at the time I hadn't realised that this was actually a very competitive thing to try and do, and that you should be applying to hundreds and hundreds of firms. And so I just applied to 3 firms in Norwich, and Mills and Reeve were one of the ones who were kind enough to offer me a job and help with the costs of the following 2 years. So it seemed rude not to come back, and for one reason or another, as the guy who recruited me to Norwich Union said, everyone calls Norfolk the graveyard of ambition. I'm sure you've heard that before, Claire, and rather harsh, I think, because I can't really imagine anywhere nicer in the country to be. So we ended up staying anyway for 30 odd years, and I'm very happy to be here too.
Well, I suppose when I left Norwich, which was in 1980, maybe I as a youngster, maybe I did think that, but I have to say, having returned to the county in recent years and bought a house there, which I haven't lived in Norfolk since I left home, I have to say it's very up and coming, and I think, you know, the royal factor probably is playing a little part in that, and the development of North Norfolk, which is beautiful, and it's a beautiful place.
It absolutely is, and of course people say it's terribly flat, Norfolk, or somebody said that. Can't quite remember who. Anyway, but it's obviously not true, as anyone who cycles a bit will tell you. Oh. It's nowhere near as flat as Lincolnshire or Cambridgeshire.
No, I lived on the Yarmouth Road, and then my parents moved to the top of Thunder Lane, so I can tell you that it's definitely not flat.
No, there is space to get a sledge out if you know where to look.
Yeah, well, that's nice. So you've got children that are Norfolk born and bred now. Well, my parents were the same. They moved to Norfolk. They weren't originally from the county, so we all end up where we want to be, don't we?
Yeah,
yeah. Go ahead.
No, I was going to say it's quite strange because of our two children, one of them couldn't wait to get away from Norfolk and is now happily halfway through a degree in Glasgow, and just absolutely loves that kind of city metropolitan life, and the other one just really can't see any reason to move away from Norfolk at all. And
nice. It's a contrast. It's contrast.
Yes.
That's the great thing. I think we all have so many opportunities now to live and work where we want to live and work, as opposed to having to perhaps. But so when did you qualify? I mean, I'm going to put this out on the. I said to you earlier, I'm going to put this out on the Law Society's Gazette, so we can both date ourselves by when we actually qualified as solicitors. When did you qualify?
Yeah, it was 1994. So yeah, that's right, 94. I was slightly older than some of the other people in my intake because I had this
yes,
kind of false start of a career in IT and systems management and that sort of thing. First with Marks and Spencers, then with Norwich Union, as it then was.
Okay, well, I qualified in 1989, so I just hit you at the post, but on that. But and so in terms of wanting to specialise, I mean, when I qualified, solicitors were only just starting on that whole discussion about whether they should specialise. I was at the tail end of a profession of generalists, as so many of us were then. Of course, specialisations were starting to emerge, and the Law Society. I can remember Roger Panoni talking at a Law Society dinner where he was encouraging solicitors to specialise. So, what made you specialise in real estate law?
They wouldn't have me in the family team when I came up to qualify.
Okay.
It's the truth. It's the truth of it. I mean, it's interesting what you say. Yes, I think I had kind of anticipated being a solicitor as being something out of the 1950s almost, particularly in Norfolk, and obviously that turned out to be very far from the truth. And the whole specialisation thing kind of goes with the size of the firm. Obviously, unless it's a very small niche firm, then the bigger it is, more departments and more specialised people are going to be. I wanted to be in a kind of a medium-sized firm, which was oddly enough, which Mills Reeve was then.
Yes.
Certainly not up in the top 50 size-wise firms. And I went through the 2-year training contract and did various different things. The one I thought I had most affinity for was the family and divorce department. They seem to have, because that seemed to have the most human interest. I think what I probably didn't realise was quite how easy it was to get sucked into the whole the dynamic of the becoming too closely aligned with the client, and how difficult it was. And it was the guy who was my seat at that time was very, very experienced and probably been around since the 50s and the 60s, and he had that down to a T. And I think I assumed it would be very easy. In reality, I don't think it was. So anyway, I had done a stint in real estate or commercial property, but it was that was when it would have been early 92, late 92, early 93. So slap bang in the recession, and hardly anything was happening. And I used to spend most of my days either looking through old packets of deeds or proofreading travelling draft leases. Hard copy documents that were going backwards and forwards, marked up in the ascending sequence of coloured pens.
Yes, yes.
Red, green, blue, purple, was it? I can't remember now.
Something like that.
But yes, that was, I need a document checking, find me a pair of trainees for a couple of hours. That's how it was then. And I thought this was soul destroying, and there's no way I could possibly have any interest in doing that. Anyway, we came to the end of the 2 years, started having those discussions about what might you like to do. And I said, well, there's no way I can do property because it's just so boring. But I do like the family stuff. And there were two of us who were interested in that. And the very long story short is that they offered a job in that team to the other chap.
Yeah.
And I thought I was going to have to go and find a new place to work. And then I got a tap on the shoulder, or got invited out for lunch at the Sue Ryder Cafe, as it was, top of on Redwall Street. And it was suggested to me that I might like to try property litigation. And
a clear steer then.
Yeah, I was a bit dubious, but it was suggested that it might fit with my skill set, and way of thinking. And someone obviously made a right call, because here we are 28 years later, and I'm still here.
Yes, of course, of course. So, yeah, I mean, in terms of real estate litigation, I mean, what's the biggest thing that you've tackled as a real estate litigator?
Well, it's difficult, isn't it? That's a difficult question. The longest running thing isn't necessarily the most complex thing, but probably the most involved. I was acting for a farmer client, the lady in her 60s when we started, and this was under an old style 1986 Act, Agricultural Holdings Act tenancy. And it was the family farm. Her landlord was her sister, younger sister, and herself. So they both owned the farm, and our client had the tenancy. And there was obviously I mean, there always is, but there was a lot of family background and probably unhappiness. It had been the father's farm, he'd had it since the 1970s.
Yeah.
My client had stayed on the farm, looked after him as he got older, gradually taken on the farm. Sister had gone off to London in the swinging 60s, and I don't know, whatever had happened hadn't worked out. So the sister wanted to get the farm or get it sold. They had to get rid of my client's Agricultural Holdings Act tenancy. And so I think it started in about 2012, the first notice to quit came, and then more and more followed, and then notices to do works, notices to failure to have done works, dilapidations notices, all sorts of things. And I think by the time we got to the tribunal hearing in 2017, I think we had about 21 different notices to quit or demands for arbitration. Anyway, they were in 3 or 4 main groups of things, but
yes,
they'd been laying it on rather thick. Not to put too fine a point on it, but it, and as you can imagine, and the listeners will guess, I suppose, this, the constant stream of this kind of thing, the need to comply with all the time limits, making sure you respond in time, do the demands for arbitration in time, get the arbitrator appointed in time. It's very easy to miss a trick in the Agricultural Holdings Act world. So that was fairly hairy, and there were various preliminary issues about the fact that there was a joint landlord. Could they do things on their own or not? Arbitrator separately advised by a legal assessor who was a QC, who answered a different question to the questions that the parties had put to him. That sent things off on a bit of a detour. We eventually ended up in the arbitration, I think it was 2017, dealing with, but they dropped some of the notices to quit. I think there were maybe 15 or so by the time that got to there. And that ended up with a three-day arbitration hearing. And we were successful, basically because the facts just weren't what the other side was saying. And I think that's a really important thing to bear in mind for anyone who's, thinking about careers in law. And I think that might be something that we're going to come on to later. It doesn't really matter how clever you are at manipulating the law and the rules and the procedure, is if the facts aren't right, you're never going to be able to make a silk purse out of a sow's ear.
No.
Or you shouldn't. And you certainly shouldn't go around telling your client that you can.
Yes, I agree. So, I've just done an enforcement of a large writ of control for the best part of 200,000, involving a farm and all the farm assets. and a son and father fallen out, and God, it's picking that apart. I don't envy you. I'm glad that my specialisation was in the tail end of the outcomes from all you litigators. That once you've got to the end of all of that, there's something to enforce, and you need help enforcing it, and then I can rock up and do that bit. And once that's done, I'm usually out there.
Well, I think as litigators, we're generally quite glad to see the back by the time it gets to enforcement. And of course, it's, for the clients, it's it's why we've done it. It's why we've been here for the last 5 years. It's why we've spent hundreds of thousands of pounds on this thing. Everyone could see how it was going to end up.
Yeah.
When we started, but my goodness, what a lot of hoops to jump through and money to spend before you get to where you very often can see that you're going to end up, assuming nothing goes awfully wrong. So I think that was probably the most involved and probably one of the more stressful cases, because so much hung on it. It was the family farm.
Yes.
There was a huge emotional investment,
of course,
in the litigation on the client's part. And and ultimately, thankfully, I won't say luckily, because I don't think it was luck. I think it was, it was a combination of the facts being right and having played the cards properly, which is another important part of litigation. We got the right result. But it's not for us to moralise about clients' actions, but quite difficult to understand what the motivation was for that 5-year fusillade of hostility from the sister.
Well, that's people for you.
But that is people and families, yes.
Yeah,
exactly.
So maybe your days of wanting to be in the family department, that maybe that was an outlet for you.
Well, yes, I wouldn't have had the patience, I think, is the truth.
Well, I wouldn't have the patience to do your job. I mean, that's a minefield, picking through time limits like that in a case that complex. So I applaud all you litigators and your specialism.
Yes, but thankfully, or not, depending on your point of view, those kind of cases are dropping away as the number of 1986 Act agricultural holdings gradually winds down.
Yes, yeah. Oh well, there'll be another emerging market, I'm sure.
I'm sure there will. I mean, we're a bit like dentists and funeral directors, aren't we? You kind of always need litigation. It's just whatever kind of litigation you need. It might change over time.
Absolutely. Yeah, I see that obviously in terms of the types of things we enforce. That we have to have a very wide spectrum of approach, because we can get chucked anything really. So we always have to have an open mind about how to do it.
Yes, everything from mass protests to trespassing horses. Yes.
Now your mass protest that gave me a few grey hairs. Tell us about that. Is that common? Are you seeing more of that type of?
Well, there was certainly. This was the university one, wasn't it?
Yes.
I think.
Yeah.
Back last February or the February before.
Yeah, beginning of this year.
Yeah, so it was after the lockdown had eased. It was a university. There was quite a lot of widespread unhappiness amongst both the students and some of the academics about various things. Some of them were nationwide concerns. Obviously, there was the Occupy movement. There was nascent concerns about energy producers, and disinvestment was a big theme. So there were some fairly major tides of thought going through the university sector, and this was one of the more politicized universities, I think it would be fair to say. So we had there was it wasn't, you know, the students doing this and all the university staff were saying, "Oh my God, this is awful. We must get this sorted out." There's quite a lot of support for what the students were supporting amongst the management. So that had its own. That makes it. Or again, that adds another layer of complexity to everything.
Yes.
But yes, I think these things do tend to come in waves, and that Greta Thunberg was very much in the news at that time. I can't quite remember what exactly for, but we were getting almost, I think, you know, we were getting a couple of calls a week from our higher education, further education clients saying, we've got wind of the fact there's going to be an occupation starting this weekend. What can we do about it? And then, you know, we give the advice, and they forestall it some way or another. Or if they don't, then we try to manage it either peacefully or non-litigiously, or ultimately through the courts. And the case that you're referring to was made particularly awkward because the courts themselves, the High Court, was coming out of its lockdown case management regime, where everything was done on paper, and you could basically just send the stuff into the court and say, "This is what's happening. Here's my witness statement. Give me a possession order. Give me a writ." And then just send someone down to the office and you pick it up, and then we could give it to you on the same evening. And they were moving back. In fact, I think the rules changed just the weekend before we were instructed on that one. So they were going back to having hearings in person. So potentially with the right for the occupiers, protesters to turn up and do their thing and cause us, raise whatever defence they thought they might be able to raise. And just everything inevitably takes longer when you have a live hearing and the requirement for 2 days or 5 clear days service. You know, all that stuff was being reintroduced. The court systems were not quite working as they should. You know, we had the CE filing system, but the court staff were saying, "Well, don't rely on that. So do email me anything that you know, please email me, Frida, in the court office, anything that you've put on the CE file, so that I can make sure it goes to the judge." And so that all adds to the time and the cost and the frustration. But yeah, we, you know, so what happened in that case was quite unusual. Was that the delay in the court system was perceived as giving too much of a window for the protesters, the occupiers, to hunker down in the part of the administration building that they'd taken over, and there was a perceived risk of really severe disruption to the university's management and ability to carry out its teaching and its research and everything else that it does. So the clients decided that rather than wait for the hearing, they would exercise their right, their common law right to peaceably evict, and that's why Shergroup became involved. In fact, I think initially we were in touch because we anticipated that you would be acting as High Court enforcement officers for the writ that we anticipated getting.
Yes, I think that's right.
And so that was really extremely useful because you were able to sit in on the initial planning meetings with the clients, with their senior management and their estates guys, and say, well, this is how it's going to happen. This is what we're going to do. This is kind of how many people are going to be involved. This is how we keep the temperature down so far as possible, how we risk manage, how we risk assess, because no one wants to be the one phoning up some students' parents saying, terribly straight, I have to tell you that your son or daughter threw themselves off a balcony whilst participating in a protest against
yes,
whatever. Yeah. So it certainly, I know the clients felt, and I certainly felt that was an extremely useful exercise. But also it meant that when the client did change their mind and decided they wanted to do the self-help route, effectively all the briefing had been done, which I think made it hopefully more straightforward for Shergroup to tee up the actual bodies to go and do the eviction.
Yes, it did, but there's no substitute for a writ. I mean, you know, landowners exercising their rights of forcibly evicting trespassers is, as you know, a common law remedy. It's whilst, you know, there's a grey area about, well, you know, you can use reasonable force to remove, and the question is, well, what is reasonable force? And that becomes a grey area. Whereas under the writ, it's quite clear that the command is to recover possession. There is no
and of course the police have statutory duty to assist.
Support. Yeah, they do. They do have a statutory duty to support, and they. I have to say, when we rely, well, actually, when we do either, the police will, because we have a good working knowledge with most police forces, they understand that, you know, that even if we're acting in an unofficial capacity, that we're agents. We're doing a job that, frankly, they don't want to do. So that you can see the police getting more and more involved as the temperature for protests escalates. But I would just say that I was just so glad that you were the solicitor handling the client, and you know, you're the solicitor that handles the client. For me, is so important, because if there's a good working relationship between me and thee, then, you know, I can talk to you about the risks, those very real risks of somebody getting hurt or worse, and you can convey that in a way that you understand your client. You know how your client ticks, and I don't have to get in. You know, I'm at the briefings, but they look to you for the advice, which is as it should be, and I treat you as my client in terms of, you know, laying it on the line for you, scary or not, about what the real situation is here, which of course we did in that case, didn't we?
Yes, I was looking back through our records. So I was trying to remember the first case that you and I had together, and I think it was a London university about 11 or 12 years ago.
Yes, you was telling me, you were reminding me about that.
That one turned out quite differently. We did have a writ in that case, but it was a building that was very difficult to get access to, and I think we were sort of debating whether you were going to have helicopters and people coming down chutes in SWAT suits and whatever. Wasn't quite that bad in the end, but
well, we do have to. I mean, I've been involved in this. You know, I qualified in 1980, and my principal was an under sheriff and a lawyer, and so I had a good grounding. But there's no doubt that over the last 30 years, the eviction process, for any of you lawyers watching this, has professionalised out of all recognition. In fact, Shergroup was the first company to have a health and safety policy, if you can believe it, around the eviction process, which because we're all required to ensure that anything is carried out safely, and so we have watched this area of business develop, and so we take a pride in you know, delivering safe results for our customers, but also for ultimately our those that we're accountable to, which is the judges themselves. I mean, they want to ensure that their court orders are carried out as professionally as possible, and I take that as a very important standard in delivering and being licensed by the Lord Chancellor to do this work. So I think between the profession, and it usually is the profession in these types of situations, between the profession and the enforcement agency, it is great to have a good working dialogue about what is going to happen, and, you know, really thrashing out the risk assessment to make sure that everybody is safe. Because at the end of the day, it is a court order. We're not the Gestapo. We're not trying to, you know, run people into the ground. We're just trying to follow a court order, aren't we?
Well, no, absolutely. It certainly has changed. The professionalism has changed enormously.
Mm.
And
Good.
back to the
That's
first,
good. If you see that, that's good.
it is, no, I think back to the first traveller eviction on a car park behind an office block in Norwich that I was involved with in probably 1995 or thereabouts, just after I qualified. I can't remember. Probably a good job. I can't remember who it was who we had to do the eviction, but I'm pretty sure it was just basically a load of heavies in long coats with with baseball bats tucked under their coats.
I that I mean, I say the sheriffs came at it a slightly different way, but I'm sure there were peculiar characters in the sheriff fraternity. But over the years, the government has. It's a great success story for the Ministry of Justice what they've done with enforcement in England and Wales. They don't talk about it enough really, but the fact that they have a modern, thriving enforcement capability, they should be very proud of that, and so should the judges, because across the world, some people can't tackle the sort of things that you give us to do.
No, I'm sure that's right,
You
and
know?
of course you can spend years and tens or hundreds of thousands of pounds on getting the judgment and the order,
Mm.
but it's worth absolutely nothing whatsoever to the client unless, well, depending on the nature of the case, but it's worth nothing unless you and until you can enforce it in some way.
And also that it can be enforced quickly and efficiently, because the client can waste time and money, going back and issuing a writ of restitution, or not doing common law. I mean, there's all sorts of parameters, as you know. But the idea is that you've done your, and probably worked damn hard to get the result that the client wants, and we want to give you the outcome that. So make sure we say on our website we want to make lawyers look like rock stars, and the reason for that is that you've done the work in getting your client to that point, and we just want to finish it off for you in the most professional way possible. And so, so it's we consider it a privilege to work with people, in the profession, and firms like Mills and Reeve, because we know, that you're consummate professionals, and you want, you're dealing with clients with hugely important reputational issues. I mean, a university has got to be hugely aware of its reputation, its persona online. I mean, it's a bit of a minefield, really, picking your way through that, I'm sure.
Absolutely right. The fact that everything is now online kind of makes it easier, doesn't it, as well? And with the one that we were talking about a minute ago, I think the one that we did in February, it was all happening live on Twitter.
Yeah.
They were,
yes.
they were, the occupiers were posting their intentions and the minutes of their meetings, and even videos of themselves being evicted by the time we got to it. It was all happening live on Twitter at 2 o'clock in the morning. The one in London 12 years ago, that was the reason that I set up a Twitter account, so that I could catch the odd whiff of what they were planning. And that was I mean, Twitter was obviously been going a long time, but it was a new thing for me. But yeah, it's surprising how free people are with their data, I think.
Yeah, well, as I say, I'm glad that you got hold of it, and we were able to have a good working dialogue. That was great for me. Really helped me out, so thank you for that. But in terms of, I mean, I know you don't have enforcement issues all the time, and you're in the real estate swim of things. What would your advice be to a young solicitor coming into either real estate or into the law today? I mean, we've both been, we've got several years of working in the profession under our belts. What would you say to a young solicitor today? Or what do you say? You might be mentoring people at Mills and Reeve.
Well, I mean, yeah, I have for a long time. I was the seat in our real estate disputes team in Norwich. So I haven't done it for the last couple of years, but yeah, I've had a very steady stream of people, coming under and through our team. I mean, by the time they get to us, they've obviously made a decision to be, or at least that they think they want to try being, a solicitor. So they've made the decision between soliciting and the bar. That's obviously a fairly fundamental decision that most people who want to be lawyers will make. You can assume that they've discounted being academics or going to the government legal service or those kind of things. I think you've got to. I think it's probably like any job, really. It's got to be something that you have a genuine interest in for whatever reason, and you may find out that the genuine reason that gives you an interest is not what you thought it would be. So, from my own case, I thought I wanted to be involved in sorting out people's matrimonial relationships and in those problems. It turned out I actually really quite liked and got some sort of satisfaction from the problem solving side of the thing, which is the I mean, a lot of our property law is really like just unraveling a giant crossword puzzle, frankly.
Yes, of course.
So it's trite to say the advice should be only become a lawyer if you are sure that you want to be one, but work out what types of career, because they're vastly different. Being a corporate tax specialist in an American firm in London is a million miles away from being a divorce specialist in a 2 or 3 person firm in a rural county. But hugely different skills required, hugely different types of satisfaction that you're going to get from it. I wouldn't be surprised if the differences actually were more than the similarities.
Yes, yeah. Well, I remember, I don't know if you remember, there was a program on, you might do, because, do you remember LA Law? There was a TV show.
Yes,
go ahead.
I had a friend who was obsessed with it, and he was convinced that Mills and Reeve was like the officers of LA Law.
There you go. And I remember the senior partner on that show saying, whatever you do, find a part of the law that you love and do that. I think if you're a solicitor or a other form of lawyer and you achieve that in your career, then you're in a good place. I know I got the enforcement bug very well even before I was a lawyer, so that's all I wanted to do. But I was exposed to it, and I guess you were the same with real. Well, sounds like you had a guiding hand to do real estate, but you've made it your own. So
yes. You've got to enjoy doing it, and you've got to get some satisfaction out of it, and you've got to feel just that occasional sort of flush of having achieved something for somebody.
Yes, yeah, of course. Yeah.
And sometimes you have the added frizz-on of having stuffed it up someone who really deserved to have it stuffed up them as well.
I get that a lot.
Am I allowed to say that?
Not that I'm, but I do like to see the underdog get their money or get their property.
Yes, I think one of the things that we might have talked about was kind of my most satisfying case, and I was racking my brains over that one, and it was a very small, short-lived, discrete piece of problem solving for a client who, and the issue was whether she was entitled to succeed to her grandmother's council house in Cambridge, and it all depended on whether the grandmother had been a sole tenant or a joint tenant along with my client's step grandfather. I can remember it properly. I think that's right. And this all came back down to trying to work out what records the council had got and how well those records had reflected the reality of what had been going on, because we were all back in the 1960s and 70s. And I was absolutely convinced that my client was, on the side of the angels, and that the local authority were not, and obviously had their own agenda. Of course, they had their own agenda in getting a moderately sized house back, that they can put a different family in it with perhaps more people. Of course, there are competing demands on local authority resources, absolutely. But the way that they'd approached it was rather offhand and high-handed, and it was an absolute pleasure to be able, in that case, to get the council to back down and to accept that they were never, whatever the truth of the matter had been in the 1960s and 70s, and I'm pretty sure that our version was right, the council were never going to be able to prove their version of events on the balance of probabilities. And I think once that penny had dropped, they became much more accommodating in both senses of the word, and that really was satisfying to.
I can imagine. I can imagine that's a great achievement, a great win.
Yeah.
Yeah, good. And I'm sure you've got. I mean, you've probably got notches somewhere. You've notched up all these successes. I hope you have somewhere, even if it's just up here.
Yeah, it's all in here. It's carefully filed.
Yeah. There's a book waiting to come out about that. No, that's good. So, I mean, you're in Norfolk. I mean, I live out near Acle. I'm in Norfolk, and I see a lot of, farmland being changed over to solar. I mean, is that something that is an emerging trend in Norfolk, do you think?
There's a huge amount of well, there's certainly a lot of solar in Norfolk and Suffolk and around here. It's one part of diversification, isn't it?
Yeah.
Farmers, especially small farmers, are under such enormous pressure from so many different sources. Some of them more local, some of them more global. It's not a surprise that the move to diversification is taken hold in such a way. So there's a relatively easy way, I think, to change land use without massive infrastructure investment costs, because generally there'll be a partnership between the landowner farmer and the solar equipment provider.
Yeah.
And we see quite a few of those going through the books of the commercial property and the agricultural property teams at work. They don't seem to throw up any litigation, which must be a good thing as well. Don't think I've ever heard of one of those going wrong. But for the farmers, yeah. I mean, goodness me, golf courses, equitation, artisan cheese businesses, growing flowers, going back to rewilding.
Yeah.
How are they going to replace the subsidies that used to come from the European Union before we left it? It's a minefield for them to navigate. And yes, if you're farming 5, 10, 20,000 acres, you can spread all those costs and those risks quite widely. But if you're a traditional kind of Norfolk or Suffolk farmer with maybe 100, 150, 200 acres, it's very, very difficult, I think, to make a living from just farming any longer. Yeah. It was getting that way when I qualified, I know, from farmer clients, and goodness me, it's not got a lot better since then.
No. Well, we're grateful for the county, in terms of, it's such a beautiful county, and solar doesn't impact that, I don't think, too much. Doesn't seem to spoil the landscape, or it's not like a pylon or even a wind turbine, is it? It's low level, it just does what it does. So
yeah. Because we do get a lot of the offshore energy people wanting to lay cables and things through a lot of Norfolk estates, landed estates. That can can cause issues. Let's say sometimes.
Is that done through a statutory kind of compulsory requirement to allow them to lay cables, or is it done by negotiation?
No, not any of the ones that I've been exposed to. Certainly, it's been entirely private negotiations between the power companies and the distributors sometimes, and the landowners. And again, it's generally that the power companies have a business model that they've used somewhere else in the country or in the world, and they're just translating it into the English law context.
Well, everyone likes to litigate in England and Wales, right?
Not if they've got any sense.
Well, we're better than some countries. So I'm flying the flag here for.
Yes, yes. I mean, somebody once quipped that it was the best and fairest system of justice that anyone could buy anywhere in the world. I think they.
When you say buy, you mean by spending lots of money on legal?
By spending lots of money, yes, exactly.
Thank you. I just wanted to qualify that.
But I think, it's a serious point. I think in that we do have a very, very high quality judiciary in this country, and that means that, I mean, decisions may be peculiar. They're rarely perverse.
Yes, I think that's a fair way of looking at it. And it is up to the lawyers to frame their arguments in such a way that gets the right outcome.
Absolutely.
All things being equal. All things being equal. So, I mean, you know, there's a lot of political upheaval, you know, which lawyers can be, you know, involved with, or standing to the side and being apolitical. I mean, what do you think that what has happened in Westminster, or, I mean, Brexit must have impacted your client community. I make no judgment on that, but just, you know, in terms of how the business community that you deal with are feeling, what's the temperature out there?
Well, in terms of just, you know, what's going on, people who are deal makers will always want to make deals, and they will do that against whatever political background is. That just has to be factored in, priced in. It all goes to risk and uncertainty, and so I think anyone who was in any sort of business, let alone real estate, would be foolish not to have increased their risk and uncertainty premium that they're building into their decision-making processes over the last, goodness me, how long is it? 6 years since the referendum. Yes, things have kind of settled down. Obviously, the results of Brexit haven't yet been fully worked through, and probably won't be. I don't think even one of the more audible members of the government had said it would take probably 50 years for the results of Brexit to fully play themselves out in the domestic economy. Even that might be optimistic, but we don't know. We all have to just carry on, don't we? You know, doing our thing, running our businesses, making our deals.
Yeah, you're right. It's very hard to predict, isn't it? And I suppose at the end of the day, lawyers just continue to advise and guide and work with whatever framework is set by government. And I think COVID was just so destabilising, and who would have seen that coming? And now, of course, we've got this wretched bird flu, haven't we? Which I was reading about in the Telegraph.
I know. It's
impacted Norfolk quite badly, I think.
It has, yeah. It's really upset my chickens. they've all stopped laying because we had to put them inside.
Yeah, I saw that all the birds have had to come in. Yes. So you know, these are the things that are acts of God, really, aren't they? They're not, you know, they're not the fault of government.
No, you can't lay that one at anyone's door, unfortunately.
No. Well, uncertainty creates, I suppose, uncertainty creates opportunity for some people in the profession. I hope that's certainly the case for you and for Mills and Reeve.
Oh, absolutely. I mean, what was fascinating for me in the kind of abstract or academic legal sense of the last few years has been the extent to which the courts have been able and prepared to step into the political with a small p arena. You know, one thinks about the Gina Miller cases, the prorogation case, and to assert the rule of law in this country. There's a very good blogger and writer called David Allen Green, who you may have come across, who has a daily sort of political and constitutional law column, and he says one of the things he says was that constitutional law was never meant to be interesting, and here we are. You know, we were having. It was making the 6 o'clock news. You know what was going on in the Court of Appeal or the Supreme Court with those cases, and that I think that was a very healthy reminder to a lot of people who aren't touched by legal process in their daily lives, that there is this whole part of our constitution, you know, quite apart from the government, that actually really matters, even though you might not appreciate what it's doing there in the background. It's the result of over 1,000 years of constitutional evolution, and it's there for a very good reason.
I mean, one of the pain points that we're seeing coming to our door and knocking on our door for help is landlords, both residential and commercial, who are, you know, trying to, I suppose, navigate their way through the tail end of the pandemic and the legislation the government produced, and just get to, you know, good outcomes with their tenants. But sometimes that's just not possible. And
Often, you know, often litigation isn't about winning and losing. It's not about taking the pie off the other person. It ends up being about how you carve the pie up between them.
Yeah.
But sometimes that just isn't going to be possible. Sometimes someone is going to end up with all the pie, and that's
yeah. Well, we're seeing a lot of that in the county court system. You know, with district judges who are not giving leave to transfer to the High Court for enforcement. Obviously, we have a vested interest in facilitating that system if we can. But really, it's because we're seeing such long delays in the county court in the eviction appointment, which you will understand, and it's costing us a lot of money waiting to get out. We're not paying.
No, absolutely.
So so I don't like to see that. You know, I think, but then I think, you know, maybe the profession needs to do a better job in convincing a district judge that there is a hardship case there to be answered. So
yes, then you come up against the internal politics of the Ministry of Justice and the Lord Chancellor's Department, and they're saying, well, these cases need to be kept in the county court so that the really important stuff can stay in the High Court, and we don't want the High Court masters having to deal with stuff that's really relatively low level. But from the client's perspective, of course, what you just want it fixed.
Yes, that's right. That's right. And we work very hard not to give the masters any additional work. we're very self-reliant, if we can be. So unlike, you know, other agencies, we try and help them, you know, help that whole process move along. But I understand what you're saying. Of course I do. All right. Well, listen, it's been a fascinating insight into your expertise as a real estate litigator and your journey to this point. What's the future for you? What are you going to do next?
I'm planning on running away to join the circus and joining a band.
Okay. Good luck with that. I don't think that's going to happen.
Watch this space.
Watch this space.
No, we've Mills and Reeve recently opened an office, most recent office in Oxford.
Okay.
which is quite nice to me. That's where I was at university originally. I haven't had the chance to go down there yet. We don't have a particular real estate or real estate disputes presence there at the moment, but that is something that we probably want to look at, you know,
nice.
And every 5 years or so, I kind of think about maybe we should move away from Norfolk, and I suppose Oxfordshire is one of the places that one might think about going to. So maybe there's a route there. I don't know.
Well, the thing is that now we're lucky. I hope you've got some flexibility in the office, that you can work sometime from home and sometime in the office. Or, but we seem to have more flexibility than we've ever had. Certainly in my professional life, I have a lot.
So. Oh, absolutely. As long as the email doesn't go down.
You have to have two. You have to have two emails. I have two in rural Norfolk. I have Sky, and then I have another because I can't.
Oh, that's very, very sensible. Yeah.
So for anyone that's working remotely, you have two internet providers, and not the same one either. Completely separate. But well, listen. I hope that the next time I'm in Norwich, which won't be too far away, we can meet up for a bite to eat. It would be great to see you in the city somewhere and have a nice lunch. So say thank you for today as well. I really appreciate your time. I know how busy you are.
It's been a pleasure.
And as I say, I hope we've served you well, and we will continue to help anyone in your department, your colleagues. We're always here as a sounding board, if nothing else.
Which is always good.
Yeah, you just need that, don't you? Yeah. Okay. All right, Julian. Well, thank you so much. For anyone that is got a real estate litigation question, and if you don't quite follow what real estate litigation is, you just want to talk to a good property lawyer, then I should definitely look Julian up. He's on LinkedIn. You'll find him on the Mills Reeve website, and I'll put his details in the show notes. Use him as a sounding board for your real estate issue, and let him guide you on where to take it if that's something that's going to help you, especially if you're in the East Anglia area. Obviously, he's got a working knowledge of that part of the world. For us here at Shergroup, another great conversation for me. I so enjoy these opportunities to talk to people that I work with, and who are so easy to discuss their work and their journey and what they think about the world, which makes for a great conversation. And then just to record it and share it with you. So I hope you found today interesting. I certainly did in meeting Julian. You can find us on shergroup.com. We're also on YouTube, and you can see us in action as enforcement agents. We film pretty much a lot of what we do. Well, we film everything that we do, but there's some of our large-scale eviction work that Julian was alluding to earlier is on YouTube. And if you want to see how we do it professionally to bring people out of trees, tunnels, and any other scaffolding that they want to erect, super glue, then just watch those videos and you'll see that it can all be done in a safe, professional, low-key, discreet way without any drama, which is really what we want for our clients. So thank you so much, everyone. Julian, great to see you. Thank you again. And hope one day we'll talk again on this channel. So thank you so much. Bye-bye, everyone. Bye-bye.